I'd like to thank the committee for allowing me to waive on. This is not a subcommittee that I normally sit on, but this is a very important issue for me. When I served in the California legislature, I was the ranking member of the Committee on Arts, Sports, Tourism, and Entertainment, and I'm struck by the fact that 10 years ago, we had hearings and considered bills on exactly this same topic, and here we are 10 years later, we still have not resolved this issue. Mr. Baker, I would like to ask about something that really concerns me, which is this issue of a patchwork of state regulations, which I know a number of our panelists have mentioned, versus the federal government asserting some primacy and preempting those state regulations. And I mean, here's my concern. We're still seeing states pass legislation in this space. In my own state of California, we just had a bill a few months ago, AB 252, which was the College Athlete Protection Act that did things like, I mean, worthwhile things like establishing a degree completion fund that schools were required to contribute to, giving student athletes rights, which I think were hard to argue against. But the problem is when we do this on a state-by-state basis, my fear is we establish this patchwork of different state regulations and we give unfair advantages to schools that are located in states that have less onerous restrictions. And that affects the competitive landscape among the schools. Is that a concern that you share?
It is a concern, and I'd actually frame it a little differently, which is there are states that literally write rules that are designed fundamentally to make it easier for them to win in the NIL space, which is not the intent of either NIL as it's practiced by Mr. Griffin and by others, but is in fact just a mechanism to benefit schools around recruiting and inducement. I think a lot of what we can do around consumer protections and around transparency and in some respects around institutional involvement and some of these other issues could be very effective at sort of normalizing the competitive playing field. Because even for a conference that's in 4 or 5 states, it gets very hard to create what I would describe as a level competitive playing field on this stuff if everybody's got different rules around how NIL works. But I do think in the end, we're going to need some federal support there, even if it's limited protection, because otherwise, one of the things I've learned in my brief period here is if a member doesn't like a rule that the membership made, it's a federal case, like the next day. And people start spending money on lawyers, and I don't really see how that benefits anybody.
Yeah, I agree with you. And I mean, I think it's pretty clear in our framework of federalism, the entity with responsibility for interstate commerce is this body, the U.S. Congress. And this is pretty clearly interstate commerce when teams from one school are traveling to compete against teams from another school and everyone involved is making money on the process. I think we have an obligation to solve this problem at the federal level. One other question for you, sir. You had talked in your testimony about your opinion that a uniform standard contract would be really helpful in providing a low-cost, low-effort option to student athletes that perhaps weren't in the high-revenue sports. What's the impediment to implementing something like that?
We're currently in the process of working that through our bylaw process, and I'm hoping to have it in place by the time school starts in the fall of 24. The only impediment might be that I might end up with the membership could vote on it, everybody could agree on it, and then I could have somebody decide that they don't like the way my or our uniform standard contract is set, and they go to court, file a lawsuit against us and say that this is unfair, when in fact it's designed to actually provide transparency and accountability and responsibility to those agents and to student athletes so that everybody understands what a basic contract looks like. But I could certainly see somebody saying they don't like my basic contract and taking us to court over it.
Sure. Well, I mean, maybe the solution to that is to allow people to opt out. You know, if you don't like the standard, then you can negotiate your own.
Well, that's true too. Good point.
I see I'm going to run out of time. One more thing before I go here. Mr. Jackson, I just wanted to compliment you, sir. Thank you very much for not reading your opening statement. It drives us crazy sometimes when it feels like, panelists read to us, we read our questions back to you. You lose that element of human interaction. I think that's so critical to successful hearings. So thanks for not taking the easy way out there.